So much for having me today. My name is Nebil Husayn. I teach at the Department of Religious Studies at University of Miami, and I'm pleased to share with you this talk entitled Between Reason and Revelation, Debates on Morality in Early Islamic Thought. For centuries, Muslim theologians and philosophers have debated the question, is God necessary for morality? And in each generation, they arrived at competing answers. The way in which this question was posed was identical to one famously known as Euthyphro's dilemma, found in Plato's Dialogues, which asks, are good deeds inherently good, or do they become good when God identifies them as such? So let me draw your attention to four major factions of Muslim scholars. Group one consisted of philosophers trained in ancient Greek philosophy and used the writings of these philosophers as the sources of their own assumptions about metaphysics and ethics. In ethics, many cited Aristotle's virtue ethics and the ideal mean between two extremes. Group two consisted of Mu'tazili theologians who blended many of the assumptions of ancient philosophy, but developed a tradition that sought to use the Quran and certain rationally deduced logical principles as starting points for their theology about God, and also their theology about ethics. They were understood to be rationalist theologians. They viewed sacred texts and the use of logic and one's faculties of reason as two equal and necessary wings for flight in the pursuit of knowledge and truth. And so these two groups can be considered the hard rationalists, so to speak, in the Islamic tradition. They deemed reason to be a source, a legitimate independent source of law and ethics. Group three, I would call the anti-rationalists. These were partisans of hadith being statements attributed to Muhammad, who rejected the authority of both ancient Greek philosophy and those dialectical theologians that you saw in group two, who styled themselves as hard rationalists. Instead, they gave fidelity to sacred texts, especially hadith literature and statements attributed to Muhammad, to inform their understanding of theology and ethics. They reasoned that only God and God's representatives on earth, primarily prophets or recipients of divine revelation, were the only authoritative sources of knowledge. And finally, I introduce to you group four, traditional representatives of orthodoxy that I would say that are at the center, who respected the views of partisans of hadith, these anti-rationalists, but recognized the importance of resolving dilemmas and contradictions that sometimes appeared in strictly following texts, right, sacred texts. They recognized that they needed to rely on their intellects to resolve contradictions. And so yes, sacred texts were authoritative sources for one's worldview, but they were also soft rationalists, and recognizing that reason played a role in interpreting such sacred texts. In these ways, they sometimes differed from group three by rationalizing solutions to dilemmas that agreed with those hard rationalists in group two. And so an example of how traditional soft rationalists, group four, may have dealt with dilemmas is the question of whether or not God has a body, right? Experts of hadith and sacred texts would say yes. Revelation says that God has hands, or God sits on a throne. Whereas many soft rationalists agreed with the hard rationalists that such texts should be reinterpreted in ways that supported the view that God was transcendent and without need of a body. And so now let's go back to Euthyphro's dilemma. Are good deeds inherently good, or are they only deemed as such because God says so? Muslim philosophers who identified themselves with the teachings of Aristotle and Plato and read the works of Greek philosophers in Arabic translation upheld the belief that there were deeds and behaviors that were inherently good and virtuous, and those that were not. One of the earliest schools of Islamic theology, known as the Mu'tazila, also upheld the view that there were inherent goods and evils. In agreement with philosophers, they also believed that God endowed humans with reason so that they could determine and identify the good and the bad. The only exceptions were those that pertained to very particular religious laws related to worship, ritual, and dietary laws. As for group three, experts of hadith refused to say that our minds were capable of deducing good and evil independent of God. There's a verse of the Quran that reads, "Perhaps you find a thing that is good, when it is evil, and then vice versa, right? They held that humans, including self-proclaimed rationalists, could delude themselves in relying on their intellects to reason good and evil. Rather, we only know what is good when God deems something to be good and informs us of it. Soft rationalists have generally deferred to the view of hadith specialists that God must inform us of good and evil, and nothing is really inherently either. They held that once sacred texts identified something as good, it was okay for humans to also rationalize that it is good according to their intellects. Whereas experts of hadith opposed that and viewed such rationalizations as misguided and unnecessary. So the point that I'm making is that soft rationalists would say, if the sacred texts tell us something is good, then we can speculate on reasons why, because we've already been guided in that direction and our intellects can help us. Sometimes people might ask, how did these different dispositions represent the different law schools, let's say Sunnism and Shiism? And I would say in medieval Islamic history, the theological and legal school affiliations of a person was less relevant when discussing their views on ethics. It was more so whether one could describe their position as hard rationalists, soft rationalists, or anti-rationalists. Those lines crossed many different legal schools and sectarian affiliations. So it's almost irrelevant to discuss the person's sectarian identity in these theoretical debates because you could find many across the spectrum in a single school or denomination. If we zoom back out and ask, how did Muslims view the question of whether humans were capable of determining good and evil independent of God and revelation? While hard rationalists, like the Mu'tazili theologian Abdul Jabbar, generally believed that humans could decipher good from evil, he recognized that it was a speculative process that sometimes posed ambiguities. He stated that only God has perfect knowledge. Humans, on the other hand, are fallible. Their determinations are neither certain nor unambiguous. He likened the human obligation to deciphering ethics to the speculative process involved in the obligation to face the house of God, or the Kaaba, in Mecca for prayer. In some cases, when you're in Mecca, it's easy to fulfill the obligation because it physically stands right in front of you. When it's out of sight, Muslims must face its direction, meaning the Qibla, using uncertain proofs, calculations, and their best estimation. The famous 12th century soft rationalist theologian Ghazali believed that knowledge of the world around us fell in one of three categories. Those matters that are known through pure reason and reproducible data and direct experience, and he mentions the disciplines of mathematics in astronomy or science. The second category are things we know only through sacred texts or the rules of worship. The third, things we know through the combined use of reason and scripture, and in this category he put questions of ethics, law, and legal theory. Muslims generally wish to abide by the Sharia, which could be understood broadly as divine ethics or God's law. The idea here is that God deems certain things to be good and others evil, and knowing such divine ethics kept one in God's good grace. God explains his views on matters through revelation, such as scripture or the teachings of prophets who are in communication with God. But the most vexing part of being a religious person seeking to follow God's law or divine ethics is that you'll probably encounter cases where it seems revelation or scripture doesn't quite talk about your particular circumstances or question. So the first circumstance where hard and soft rationalists made their contributions to questions on ethics and Islamic law were in these questions, legal questions involving doubt. The reason why places of doubt or uncertainty were key sites, it was in those cases that worshippers were searching for answers and guidance, and it wasn't clear that simply deferring to the Quran or a precedent from the life of the Prophet was possible. So in these new circumstances that sacred text didn't directly discuss, what did Muslims say about their ability to determine good and evil? Some conservative hadith experts and soft rationalists upheld the presumption of a legal prohibition against engaging in actions that weren't made expressly permissible by God as a worldview. The analogy that they made is that this world is God's property. So we can only use that which the owner of such property has allowed us to use. It's in such circumstances that some anti-rationalists said that if Muhammad and his companions never used stringed instruments, such as guitars or violins, then one should consider their use unlawful. However, since Muhammad allowed soldiers in his army to beat drums, then the use of drums was considered lawful. Another example is that a few hundred years after Muhammad's death, when Muslims first discovered coffee, that some relied on the principle of precaution, out of an abundance of caution that one should avoid engaging in a particular activity in case God considered it unlawful. And so even if they didn't go so far as to say that drinking coffee was unlawful, they said believers should, out of precaution, not drink it in case it was unlawful. And so I want you to take note of the subtle difference between stating X is unlawful and the legal opinion avoid X because it might be unlawful, right? And just to hear some of your speculations and your contributions, can I ask, why would anti-rationalists, why would super conservative hadith experts be fearful of giving a fatwa or a legal opinion claiming the first view that X or coffee is unlawful to consume? Why is it that they would go for the second in their worldview? Imagine you're someone who believes you get all your answers from Quran or sacred texts or revelation. Yes?
Because if there's no evidence in the text, you can't make a judgment without having a reference to something else.
And thank you, exactly. And what would be the consequence of them doing that in their worldview? For example, for them in the hereafter.
Because then you're using your, then the only facility you're using is pure reason. You're not referring to a sacred text. You're using pure rationality to attempt to decipher something that doesn't exist originally in the text.
And how would God respond to that in their worldview?
When you say it's haram or sinful in essence to put words or to make a judgment or declaration in His name?
Exactly. That was the fear that they had, that they would commit a major sin. Even if they speculated, even if they thought, they estimated that coffee might be unlawful or whatever it is might be unlawful, instead of saying it outright, they abstained from giving that the express legal opinion on new matters out of fear that deeming something prohibited that God had made lawful, and vice versa, that you'd be accidentally claiming something that wasn't true, and that God would punish them in the hereafter for committing that major sin. So even though the consequence of their legal opinions would be the same, that people are expected to abstain from that thing, notice the subtle differences that they have due to their theological beliefs and how they go about saying on these ethical questions or on these legal questions why they would say someone should abstain from an activity or engage in it. Similar to anti-rationalists, there were some rationalists who were also conservative and practiced precaution in regards to new cases. For them, the principle of precaution, I think I mentioned it on the last slide at the very bottom, ihtiyat, was the rational and best course of action for saving oneself from misguidance. Right? If you maintain that principle of precaution approach, the example that they gave would be, for example, if you have 2 plates of food or 2 cups filled with a drink, and you're certain that one is poisonous, and even a taste will kill you, whereas the other is good and will satiate you, but you're not sure which one is which, what do you do? Right? For them, they would say, prudence requires us to follow the principle of precaution. Right? You can consider another example where the stakes aren't as high. What if you have 2 cups, but one is according to dietary law lawful, but the other one is unlawful, but you don't know which one is which? What do you do? Right? In such cases, the jurist would say the prevailing procedure, when presented with this uncertainty, when one road leads to perdition, is to take the road of precaution and avoid the choice altogether, if you can. And as justification for the reasoning or this principle, they further cited the verse of the Quran, and cast not yourselves to perdition with your 2 own hands. That's chapter 2, verse 195 of the Quran. So what am I getting at? Whether you are a conservative anti-rationalist or even a hard rationalist, sometimes the procedure that you took in times of doubt would be parallel to one another, the same. You can appeal to a verse of the Quran, or for these hard rationalists, they said the principle of precaution is the most prudent thing to do, according to their common sense. But that's a conservative approach to questions of law and ethics when you're faced with doubt and uncertainty. There are also those jurists that had liberal sensibilities. Many hard rationalists presume the permissibility of anything that hasn't been expressly prohibited by appealing to what one might call the halal principle, which stated that the legal presumption concerning things is their permissibility. Aslul ashya al-ibaha. Or simply put, all is permissible except that which God has already identified as unlawful. For these liberal jurists, they assume that most things would be lawful until clearly proven otherwise, right? And this is the attitude that jurists have had about new technologies, engaging in discovery and studying emerging disciplines, or something as simple as wearing new types of clothing, or eating new types of food, or playing new types of sports. The principle is far-ranging, but these things are considered well and good until the evidence is clear that there is an aspect about it that is harmful to the human or unlawful. So one historical example in which the halal principle was employed among liberal jurists was the case of smoking tobacco in the Muslim community. Initially, jurists of the 19th century held the opinion that smoking wasn't necessarily unlawful. Maybe it was a practice that should be discouraged because the smell was considered a nuisance. It was considered mubah or halal, permissible. But once the scientific research was overwhelming after the middle of the 20th century that smoking actually killed people, many jurists changed their opinion to it being an unlawful practice. So the halal principle was a legal maxim that jurists taught to represent their values. Legal maxims, known as qawa'id, represented the logical articulation of legal axioms in light of the sacred sources, legal inertia, and the collective practice of judges and jurists. I want to draw your attention to moral questions that Muslims and non-Muslims have asked, and how Muslim judges laid out their assumptions in legal maxims and procedural principles to guide their thinking in answering these questions. The first one is the, I guess you could say, timeless question: can you steal a loaf of bread if refusing to do so will lead you or the person you like to save from dying from hunger? Right? By a raise of hands, who would venture to say that the answer was no? And why? That you cannot, steal that loaf of bread to save a life or to save a life of another. Okay, just one. So that's the minority opinion. Would you
finish the talk and then?
Well, I mean, I guess. Okay, and then who would say yes? Raise their hand and guess yes, and why? Okay, we got 1, 2, 3, 4. So you see, there are more people are willing to speculate that it might be okay to steal to save a life. Well, for this question, there have been jurists who stated necessity renders prohibited things permissible, right? Or necessity knows no law. So eating unlawful items like livestock or harvest that belong to someone else, right, to save a life, would be considered, out of necessity and a justified action or a reasonable one. But the question here is, when you steal something that belongs to someone else, what are the rights of that farmer or that shop owner whose rights have been violated in such cases? Right, you've stolen that bread or livestock or whatever. How did jurists respond to that? The maxim that they thought about in those cases is necessity does not invalidate the right of another. Right? So the state, or perhaps the party that took that product, if they can, should provide compensation for the owner. And if that party can't do it, then that would be the way in which arbitration is done. The judge or the court or the state, if they see that there's this, that there are reasonable or mitigating circumstances, that they would compensate the one who has faced that loss. Another, I guess, ethical question that people ask: if someone does something unlawful to you and harms you, is it lawful to reciprocate that harm? I would say that people have used this ethic of being the victim of violence or harm as justification to reciprocate with such violence after a period of time has passed, right? Not even in the moment, right? But that because that happened in the past, one is ready to respond in kind in the future. And this mode of thinking, we've seen this even on an international stage, right? When governments respond to one another to attacks. There is this principle: do no harm or reciprocate it. La darar wa la darar. And this is attributed to Muhammad himself, meaning, in general, it's unlawful to harm others, but when someone does something unlawful towards you, it is still unlawful to reciprocate that harm, right? In that unlawful way. So if you're, in that situation, well, we can come back to that. We can come back to that question and see how jurists perhaps provided exceptions to that rule and why they provided exceptions to that rule. But remember that as, you could say, another way, another alternative to eye for an eye, tooth for a tooth, and so on. If you're accused of a crime or a debt, how are such claims treated? We live in a time in which people are accused of impropriety in all of these different ways, whether it's in ethics, in the way that they use funds, in between individuals. And so, in matters of guilt or obligation, humans are assumed to be innocent unless otherwise proven, meaning there should be conclusive evidence that a person committed a crime to hold them accountable for it. Not only is that a presumption that perhaps we recognize in American legal systems, but this is one that judges held to in the medieval Islamic tradition. And so, jurists said also that God must allow humans to appeal to what we can call the exemption principle. Humans were exempt from all liability or blame in this world and in the hereafter, meaning God would not punish them for sins or unlawful actions which they did not know to be a sin or unlawful at the time of their commission. And so we have examples of this where Muhammad is stated to have said, in my community, individuals are relieved of what they do not know. Right? And this was understood as the براء الذمة من جهل. And so if you thought of the counterfactual to this, what would be the opposite? You accidentally do something that is unlawful, and you're punished as a criminal or considered sinful before God for the commission of those actions, and that would be seen as unjust or unfair. So thus you have these types of principles. And so where did that principle play out between judges and between jurists in Islamic law? We see this principle played out in every school of thought. That a judge was exempt or free of blame when their mind and heart considered the evidence to be compelling to follow a particular legal opinion or ethical opinion that they considered correct, but they were actually wrong in the sight of God. Right? So when you have two lawyers or jurists who hold contradictory but well-reasoned opinions, both opinions should be respected in the community. So it facilitated a culture of pluralism, where if in early Islamic history there may have been people who said, I'm right, you're wrong, go to hell, or that, I know I'm right and I know that God will punish you in the hereafter. Once this ethic of the exemption principle became accepted among jurists, there was this culture of pluralism and tolerance in which people recognized that they had, there was room for disagreement amongst one another, and that didn't mean that disagreement implied misguidance. So, what were the contributions of rationalists in framing Islamic law and ethics? We can see first that they developed all of these legal maxims, right? All of these maxims and procedural principles, known as the usul al-amaliyya, were developed and derived through a process of induction, in Arabic known as ta'mim al-khas, or extrapolating general principles from specific edicts established through sacred and authoritative sources, so the Quran, prophetic practice, consensus. Or in some cases, these maxims were attributed to Muhammad himself, and I gave you examples of that, and these might be back projections, right? 200 years after the fact, he's described as saying these things, but in either case, famous jurists justified their legal opinions through these legal maxims. And they became proverbs. They were proverbial principles derived from this detailed reading of the letter of the law in an effort to identify the spirit of the law and its universal principles. After this, the second contribution of rationalists was to critically uphold and identify the role of maslaha, or the greater good, in legal reasoning. Third, they developed literature that defined the objectives of what you could call divine ethics or God's law. Now, I've already discussed the very first thing that you see there in depth, so I want to turn in these final few minutes to looking at these second and third contributions. So, maslaha is understood to be the search for the greater good, or what one might call the application of utilitarianism in the legal reasoning of scholars. One might say the best proof that soft rationalists recognized the use of one's intellect in addition to the sacred texts was their appeals to this ideal of the greater good, or maslaha. In such cases, reason appears to be a legitimate, independent source of judging cases. When jurists would set aside a legal precedent or a legal norm, such as the application of a ruling or a punishment, in a case that historically would have required it, they would state that they were setting aside that historical precedent out of respect for a greater good, or out of respect for mitigating factors that would make the normal course of action unreasonable or more harmful to the parties involved. It should be noted that finding the greater good required a person to use their discretion or rational faculties to differentiate good from evil, or choose the lesser of two evils, or what one could call the optimal choice if you have two good choices. And this is a reliance on one's reason as opposed to sacred texts alone. And so an example of this, as you see up there, or examples could include responding to violence with violence as a deterrent. So I said I would come back to this. You have this principle that says you may not do harm or reciprocate harm. But then you have this other principle asking what is the greater good and what is our responsibility to the greater good. So again, going back to this question of geopolitics and wars between states. What are the consequences if you have an aggressor that attacks another sovereign country? What is the response of that sovereign country? Is it to respond likewise with violence, even though harming other citizens or harming other individuals is considered unlawful or unethical? What would be the reasons that leads one to do that? Perhaps it could be self-defense right in the moment. And then how do we understand self-defense, right? And so there are those that argued that the use of violence as a deterrent actually saves lives. Meaning, if one does not respond to such aggression or to such attacks, then this will lead an invading force or another force to destroy the entire country or destroy the government altogether. And this would be a greater ruin. There would be greater fasad, so to speak, if one does not stop an aggressor. Other examples of this include government confiscation of private property. Right? Generally, if you own a piece of land, your rights as the owner was respected, but There is the principle of eminent domain. Sometimes governments would seize property, even though that is your right, and say, look, there is a greater good. There is a greater good because we need to build highways, or the greater, public needs to use this. We need the natural resources, water, and so on. And so in those cases, remember the principle that the owner of that property should be compensated, right? And so we see caliphs sometimes citing this principle of the greater good and eminent domain, and then offering compensation for those individuals who lost their real estate. Other examples include outlawing the sale of possession of certain products. Clearly, illicit drugs would be an example of this. If it's viewed as harmful to citizens, even though in general humans are viewed as having the right to own whatever it is that they want, that God gives them the right to do this. This is an example where a ruling sovereign could say, no, there are certain products that would be harmful to society, so we will prohibit the sale or possession of these products. And the example that I also just gave of setting aside punishments due to mitigating factors. So if stealing is generally considered unlawful and thieves are punished for stealing, the example of stealing during a time of famine or to save a life and so on is given in Islamic literature. Najm ad-Din al-Tufi, who died in 1316, was a rationalist, humbly jurist, and he was a humbly jurist who held that the basis for understanding the entirety of Islamic law was the belief that God only wants the greater good for humans. God only wants maslahah. The desire of God and hence divine ethics, he believes, is stated in 2 verses of the Quran. ما يريد الله ليجعل عليكم من حرج وَمَا جَعَلَ عَلَيْكُمْ فِي الدِّينِ حَرَجٌ, or the 2 verses. And God desires not to impose hardship or adversity onto you, and we have not created hardship or adversity for you in religious matters. Meaning, he says that the spirit of religious law, Islamic law, the spirit of religion is one in which God wants the greater good, and God states it twice in his revelation. And so therefore he had complete certainty that whenever he would try to provide a legal opinion, it should be one that utilizes this utilitarian principle. In my final 2 minutes, I want to look at the final contribution of rationalists to Islamic law, and that is the genre of literature known as Maqasid al-Sharia, or the objectives of Islamic law. As the centuries passed, jurists rationalized and contemplated how one could understand the foundations and basis for all of the religious laws that they followed. They came to the conclusion that Islamic law considers a number of things to be sacred, and Muslims have a responsibility to protect those entities. They believed that all of law could be collapsed into 6 values: the protection of the sanctity of all life, family, property, intellect, religion, and the dignity of a person. In this way, the Sharia came to represent a set of inalienable rights and protections that God had guaranteed for all humans, and that governments were not allowed to violate or take away those rights from humans. And so clear crimes discussed in the Quran that were clear violations of these objectives included murder, right, protection of life, persecution, protection of religion, theft, protection of property, adultery, fornication, false claims to inheritance, that was viewed as protection of family, slander, the protection of dignity of a person, and so on. All of these were considered sacred values, and jurists said if we could speculate and rationalize and justify why these things are considered unlawful in Islamic law, it would boil down to one of these 6 objectives of God's law. Thank you very much for your patience.
Thank you very much for a super excellent conversation, and actually it opens the door for bothering you again and bring you back to really open this discussion and consequence conversation.
Sure.
I just want to maybe through the first, not question, but maybe comments and equal comments on my comments. So this legal or jurisprudential assumptions, regardless of the schools of thought, is based on the principle that the Quran provides not only ontology, but also epistemology and methodology, correct?
Yes.
So on which one do you think they fight more? Because it seems to me that all of them believe that if they go to the text and of course the Sunnah, not only they understand how the word works, but also how do they know what the word is all about, and of course the method that they develop to. So that's my sort of a generic question on that, and then how they differ on these three. That's my first question.
Ideology, methodology, and epistemology.
Yeah, ontology, of course, I suppose they all can agree. I'm not sure actually about that, if ontologically they agree on how the word works. And then, of course, from that into epistemology of how we know what we know, and then the method of doing that. So I suppose the Islamic legal scholars either fight over the three or they disagree or agree on the consequences of that. So that's my first large question. And my second large question is about the agency of identifying the law and then implementing, and how this agency evolves from person to the sovereign. Is person sovereign, or is the state sovereign eventually? In terms of identifying the law and implementing the law, and what are the boundaries of the sovereignty and individual. So these legal renditions are written for individual to read, or for the state to implement. So that's sort of my two big questions on that.
Okay, thank you very much. In terms of ontology, I think I would briefly just go back to the beginning of the presentation, in which I argued, or I asked the question, how did philosophers view the place of reason, or even, I guess, the title of the talk, Between Reason and Revelation. And I could just briefly, if I could briefly talk on that, it would be that there seems to be three important models. One where reason and revelation are equal to one another in terms of their truth value. Muhammad Abdu stated it most recently in the early 20th century, that God is the author of revelation and the author of nature, and the two can't contradict one another. And so he was open to reading the book of nature, which is understanding, like through observable data, understanding the world around us, and accepting the conclusions of reproducible data, this hard scientific method, one could say. And then also understanding revelation as this equal source of truth, and harmonizing and recognizing that the two come from the same creator, and so there should not be any contradiction. And of course, that's an ideological commitment to assume these things that may or may not be true, the way that a rationalist states that. And then there are those who said that revelation comes first and reason is only a tool. And I would say if the first view is the hard rationalist view, the second one is the soft one. Meaning we give precedence to the Quran, to prophetic example, the example of Muhammad, and the received tradition, and we're only using reason in a very limited capacity, and I think that became the orthodox, or the most common way of understanding this ontology of God gives us revelation, but he also gives us the ability to use our discretion to interpret the text. So it's like reason with a limited capacity. And then there are the anti-rationalists that said, who associated the use of speculation and their rational faculties with Satan. That Satan is viewed as debating God and being exiled from heaven or the garden, because instead of obeying God, following divine command theory, so to speak, he is speculating his own sense of what is right and wrong, and that's why it's misguided. I think those are the three large ways of understanding the role of reason. For me to get into the specifics of the relationship between God and humans, or the roles that specific humans might have, would be so detailed, but I want to put that out there. And then methodologically, that means if you believe the two are equal, let's say that hard rationalist perspective, I would argue that you are, maybe this is a provocative one, but it's like following the philosophers, your own assumptions take the driver's seat, and then from there you're looking for confirmation from religious texts. And in terms of those who looked at reason and revelation where reason is limited, the soft rationalists, it seems that the sacred tradition, the weight of the sacred tradition has a large role. It's very heavy, and then sometimes when you have contradictions or dilemmas or problems, they're willing to resort to using the views of the hard rationalists. And then with the anti-rationalists, it was very much, even in the face of dilemmas, in the face of hardship, they were still willing to follow revelation, like against their own sensibilities. As to the second question of agency and identifying the law, is it the person, is it the state? I would say legal authority after Muhammad went to his companions, meaning when he died, every companion, most senior companions probably viewed themselves as legal authorities, in that they did not see themselves as obliged in following the legal opinion of another person if they had their own opinion. But it's at that time that some were recognized as having great legal acumen. Some were not like others. So, Ibn Mas'ud, Ali ibn Abi Talib, and other individuals, specific companions were viewed as experts of the law, and they had circles around them and people followed them. And so all of these legal circles existed, I would say, on an ad hoc basis, and from there you had jurists and judges who also had their legal circles, and from there you have these networks where they viewed themselves as independent legal authorities who can have differences of opinion. It's hard for me to speculate when or how the state would intervene in some matters. So, for example, in public matters such as state property, going to war, taxation, clearly the caliph or the state had the ability to uphold its own view on the matter. The ruling authority, the ruling sovereign, in consultation with jurists, would implement their legal opinion on it. And sometimes on these not even sometimes, it seems that on public matters, people were obliged to follow that opinion. But as time continues and the law becomes more complex, the caliph or the state apparatus has to rely on scholars of the law to interpret these things. And at the end of the day, within 200 years of Muhammad's death, there are recognizable scholars of law and schools of law, and they are the authorities on these matters.
So the conclusion is, I think, in the ontologically there's a little fight, but on epistemology, especially on method, there's a lot of fight. There seems to be achieving.
Sure. Unless, if you're saying epistemology includes how they understand reason, then yes. But I would say the ontology might include that, and so therefore there might be differences from that perspective, from that dimension.
I'm just moving my students in the seminar so they can ask you questions.
Yes.
Moving over here, and we may have to move anyways after 12:30.
We
We don't want to
we have
stop.
30 minutes still.
Yeah, we don't have to stop here. Hey, this is wonderful. Nebil, if I may call you Nebil.
Yes.
One of the problems that we've had in our course is the issue of divine command, right? That the commands sound arbitrary and God is not accountable to us, because even as the Hebrew Bible says, our ways, God's ways are not my ways, God speaking, is not, your ways are not my ways. So
Yeah.
even Aquinas in the Summa says, if God commands you to steal, then it is not only right, but it's even according to natural law.
Right.
It's one of the most remarkable passages that we came across in Aquinas. It seems that comports well with the more traditionalist view, that if the Quran says something that to your intuition sounds not only illogical but amoral or immoral, you still have to obey it, because revelation trumps everything. On the other extreme, it's reason can overrule revelation. Immanuel Kant, right, said no, if something in the Bible is reprehensible, and by the way, he believed that it was, you should not obey that stuff, right? When God commands Moses in Deuteronomy 20:16, go and exterminate the Canaanites, I think a traditional would have to say you got to do it because God commanded it. But Kant says no, that is totally reprehensible. So on this the two extremes, right? You're articulating that middle ground. That's the hardest one, right? Well, you have to want to combine the two, but that middle ground seems to be in the bill unstable, right? It seems that the extremes seem to win, right? Because they're more well defined, right? It's very clear. You obey the command. If your intuition does not comport well with what it says, you damn the intuition, right? On the other hand, if reason says no, then reason overrules revelation. Can that middle ground survive given what I call the instability of it?
Yeah, I would say it's like a perennial tension in the practice of religion, that you have these questions where new circumstances and new cases come about, or our understanding of ethics gradually shifts so that there are pre-modern or ancient texts that seem to be upholding perspectives that we now deem problematic. And how people deal with that is, it's across that spectrum of hard rationalists, soft rationalists, and anti-rationalists, right? And take the case of slavery, that you have revelation that seems to be legitimizing the practice of slavery in the ancient world. The hard rationalists, like you kind of alluded to, could use the principle of the greater good. Apofi would be an example where it says, even if it is an established law in revelation or scripture, we can use our discretion to set it aside if it seems to be harmful to humans. Like, God gives us that right to do that because God wants the greater good for us. So if something seems to become harmful for people, it can be set aside. The anti-rationalists would say, our conscience be damned. Consensus of the world be damned. Even if they abolish it everywhere, we'll continue to practice it, in these ways. And there are people who say that because God's law allowed it 1,400 years ago, 2,000 years ago. And then, as you might recognize, there are soft rationalists in the middle, and they'll continue to face this dilemma of being pulled in one direction or another. And I would say consensus builds with time, and usually the hard rationalists, maybe not usually, sometimes the position of hard rationalists become the traditional view. And sometimes the anti-rationalist position becomes the extreme, and it dwindles and it disappears. But then sometimes that happens also with hard rationalists. So I would say it's the dilemma of practicing religion that you'll always have this, or in philosophy.
I'm sorry, it's my son. And
Please.
Danny, I'm in
Yes.
electro. I'll put them on him. Thank you. All right.
So I'd like to add two points that may enrich or complicate this picture a little bit. One is what we might broadly call the virtue ethicist position, which sort of happens along this continuum, but with a specific result. Essentially, based off of my experiences reading the text in the period that I work on, which is in the Ottoman period, you often encounter people who have such a closeness with God, right? You encounter testimonies about people who have somehow developed themselves in such a way that without reasoning and without referring strictly to Scripture, know what is right and wrong. So, you'll have a Sufi saint who will eat a piece of meat and know that it is not halal meat somehow. Or he'll, conduct a business transaction and know that this money was somehow haram money, right? So in instances like that, this person's virtue has developed to such an extent that they have arrived at proper conclusions about ethics through essentially what we might call a supernatural way. And of course, the model for this is the sinlessness of the prophets, right? Or the imams who cannot commit a sin and cannot lie, simply by virtue of their divine grace. So this creates another way of like arriving at ethical behavior through neither rational debate nor through referring to the scriptural text. And this was in the mix. It was not really fully theorized, right? Because sinlessness is sinlessness. It's kind of magical, right? But I want to say that this is something that you encounter a lot when you see discussions of Islamic ethics, the ethics of the saint, the ethic of the wali, that's natural and divine given. So I want your thoughts on that in a second, but I'm going to add one more thought. This is the way that the concept of maslaha, the way you are describing it, or the theorist that you brought up, the concept of greater good was essentially used to legitimate a utilitarian ethics. And you bring it up with a positive valence. But I note that in the Ottoman context that I'm most familiar with, you see the concept of maslaha being brought forth to justify pretty much anything the government wants to do, anything the state wants to do. If the state wants to, execute 100 innocent people in a village for some one thing that one person committed, they'll do so, and they'll say because of maslaha. So the concept of greater good here is essentially a cover for real politic, and also because the concept of maslaha was incompletely theorized. I mean, the Quran says perform salihat, perform good deeds, but it does not really give the jurisprudent a lot of grounds for developing a complex theory of what salihat are. This means that maslaha can be used as this kind of flexible and perhaps abused concept. So those are the 2 points that I want to raise, and wonder what your thoughts are on that.
Sure.
Yeah.
So
Let me piggyback with that as a footnote, and then maybe mix it up because I don't want to take more time. Do you see any contradiction, tension between maslaha and maqasid al-sharia? Because in practice, let's say in Iran, for example, a lot of discussions happen around that notion that maslaha usually leads to the questions of pragmatic Machiavellianism and so on. But maqasid al-sharia is ontological, and therefore prevents playfulness with law. So that's an interesting tension which I'm using as my teaching actually to think about what is the normative forward-looking part and which one is the status quo go along with what is the generic maslaha is. So I think that's an interesting, maybe you kind of think about it and
Thank
talk
you.
about it.
Yeah, no, I think you're answering the question for me. Okay, great. So, the title of the talk is Between Reason and Revelation, but I've seen a medieval Islamic text, a study of medieval Islamic literature that says reason, revelation, and divine illumination.
Right.
So the
Right.
third
third
stream
one.
of knowledge would be this idea that there are certain individuals who are privy to intuition that is guided by God. And the way that it's defined like ilham, or this divine illumination, is when God casts the truth into the mind of a saint, and that revelation or inspiration is unspoken, right? So they're driven in a direction, but there isn't like explicit revelation like the one that goes to a prophet. And what role does that play? In legal, in a courtroom, this question has been asked. Divine illumination is considered inadmissible evidence, that you can't have judges or lawyers or claimants appeal to non-admissible evidence like dreams or intuition or inspiration or so on, because of these different maxims and legal assumptions and presumptions. And in fact, the question has been asked when a judge has direct knowledge of the truth by alternative means, and the alternative means could include this divine illumination, but a certain sets of evidence have been presented to him in the courtroom. Does the judge rule by that alternative means or the evidence? And he's required to rule by the evidence, in spite of that personal knowledge he might have that others aren't privy to. So in the case of the, in the context in which we're speaking of, legal methodologies and ethical presumptions and questions, that is the norm. Because otherwise, as you know,
Thank you. That's a
the guardrails are off,
yeah.
and then
Yeah.
and it would be unfair. In the spiritual life of individuals, because you had saints and individuals who were believed by their followers, their disciples and partisans of being the paragons of justice and ethics, they became ethical teachers, and they were trusted in their opinions because of that, and they were revered as sacred figures for that. So that's certainly there, especially in the last 500 years post Ibn Arabi. Ibn Arabi is this famous Andalusian mystic who relies on divine illumination to discuss his views on everything in Islamic history, and he was the most one of the most popular thinkers and most influential thinkers of his time and then afterwards. And so, yes, that perspective is definitely well known and part of Muslim culture. The second question is the role that maslaha might play in its negative capacity, and for sure.
Nabil, can you give us in English, maslaha?
Sorry, the greater good, the idea of
Utilitarian. Okay.
Yeah, utilitarianism and the possible harm. Anti-rationalists have been clear in viewing the discretion of jurists from the very beginning to the end. That this is dangerous, and because it's sinful and it may not represent the ruling of God. But you're pointing to examples in which people could claim in pursuit of utilitarianism the support of genocide
or anything
else. And I would say again, this is a perennial issue, even when you're an anti-rationalist and you put no role in the role of reason in understanding the right from wrong. And whether it's the other side, this is a problem in whatever perspective you take, that you can justify just about anything, any awful thing that you can think of, and humans are capable of doing it. But Professor Misbahi pointed to the fact that there are some who theorize, well, following the spirit of Allah, the protection of life, property, religion, and so on, is the status quo. These are the presumptions that our law should be doing that, and that when one appeals to maslahat or the greater good, you're doing that as an exception, right? You're departing from the legal norm or the precedent, what is hegemonic, for some sort of due to some sort of circumstance or due to mitigating factors, and if you use it in that way, then it should keep the community guided.
Nabil, by the way, feel free anybody to ask questions. So
Perhaps I could ask if there are, for those
Yes.
who have not asked questions yet, to give them a chance to ask a question of clarification, or before we return to the professors who asked questions. Yes.
Could you? I'm assuming you're familiar with the concept of concealment, right? If you commit a sin and nobody knows about it, then Allah has essentially concealed that in your favor, and you shouldn't speak of it. So how does that apply, actually normatively? I know you're not supposed to talk to your imam about, or theoretically, you're not supposed to even reveal sins to your imam. You can say, I know a friend, or I know somebody who's experiencing this. How do I go about this? How does that apply in ethics or morality, or even normatively? If you have a court case, right, wouldn't your sin be essentially revealed to everybody?
Yes, so I think the way that we could understand that principle is perhaps in the United States, the right to invoke the Fifth Amendment, where you don't have to incriminate yourself, or you can refrain from incriminating yourself. And it seems that we have proverbs attributed to Muhammad, or cases where he tells the individual who feels a lot of guilt that they've done something that they believe is unlawful in the sight of God. They haven't harmed anyone else. That's key. If this sin is one that doesn't involve other parties, Muhammad is stating that God has, in protection. I guess you could say this is in support of protecting the dignity of an individual. That God continues to, veil the world from that private sin that you've committed, and don't reveal that to others, and force the state to become involved in these matters. And so, I guess examples of this could be intoxication. So if drinking alcohol and becoming intoxicated is something that is considered unlawful in Islamic law, and someone did that privately, we have examples of caliphs stating to protect the dignity of an individual, we don't bust through the door and check to see who's drinking alcohol and who's not. And there are other examples related to intimacy between individuals, between sex, like, in matters of sex, that if there are certain relationships that the community recognizes as lawful and others unlawful, and someone is engaged in an unlawful relationship with another human, as long as they keep that private in their own homes, the police are not supposed to come in and drag people out and punish them for having these types of relationships.
Nabil, so law does not include necessarily sin. The distinction between sinfulness and lawlessness, crime versus sin. In terms of articulation, the private versus the public, and so on. And even in the public, it seems to me that sin has a category of forgiveness written all over it. But crime, probably not.
So
I think maybe that distinction is being discussed, because I'm certainly anyone who can discuss heavily about this private space. But the nature of your act as defined as sin or a crime. I think that distinction could be very illuminating and should be.
Yes, so an example of that would be, let's say, the choice of an individual to wear certain types of clothing, right? One of the most controversial questions in the modern period for, conservative Muslim countries is the role of the headscarf. Because this was seen as a private question, to make it a crime, you had certain countries that said, oh, no, we have a national dress code, right? They can't even say that it's really like a religious practice, because like the religious practice might be something that's left to the individual. But to say that we have a national dress code then makes it something in which they can intervene. And so you see these types of tensions, I guess, as you're stating, between sins and crimes, and then making a sin a crime. Another one are these blasphemy laws, that someone can disbelieve in God or in Islam or whatever, if they're living in Muslim majority countries and they come from a Muslim family, and they can keep those opinions to themselves, and that's viewed as something that the state should not intervene with. But once it becomes a public matter in one reason or another, you've seen examples in the pre-modern times and modern times where people are punished for blasphemy.
Reformability of Sharia. In the Gospel of Mark, the traditionalists would say you cannot do anything on the Shabbat, right? And Jesus says, but David ate bread because he was hungry. The holy bread is supposed to, right? So that, I think you gave an example analogous to that one. And the other one is, Jesus says, the law, man was not made for the Shabbat. The Shabbat was made for man, which speaks to this principle of utilitarianism, that the religion has to be reformed for the benefit of humanity. And if it is not for the benefit of humanity, then, we can change it. So here's the question. How far can you apply that principle of the benefit of humanity, maslaha, right? How far can you push it, right? Aquinas even says some parts of natural law can be changed, but others cannot be changed. But then we found in class it was very hard to determine how do you draw that line of demarcation, because what are the parts of the law, Sharia or Revelation, that are not reformable, right? And what are the parts that are fixed and immutable? Is that, how far can you push that envelope? Is that a legitimate issue in Islamic jurisprudence?
There are different professors who present the study of particular religions in different ways. Within the Abrahamic communities, because I've taught courses where we're just talking about Islam, or co-taught courses where it's Judaism, Christianity, and Islam, I've swerved in a direction where I deny exceptionalism in terms of Islam or Muslims, that all Muslims are unique in X, Y, and Z, or Islam is unique in X, Y, or Z. In what you just said, the parallel is like, you can't, like, I don't see any difference. Like, it's a perennial issue that Jews deal with, that Christians deal with, that Muslims deal with when asking these questions on the role of utilitarianism versus the law versus
The letter versus the spirit,
the letter
right?
versus
Paul.
the spirit, right?
Right.
Like, you have rabbis who go back and forth on this, and you have different schools of thought. Christians who are debating this, and then you have Muslims who are debating this, and I think it's a perennial tension in practicing religion to deal with these types of moral questions.
Yeah, that's sort of the idea I was kind of thinking in my head, like the letter versus the spirit, like, because it gets me thinking, like for example, like, say my brother like wrote like a book of things that I should do, like, to respect him after he dies, right? And I read the book and I say, Roger, you told me to take Alvarez's class, but I don't think in spirit you mean that.
Mm-hmm.
And imagine my brother's like, no, that whatever you say is the spirit, that's not what I wrote, is what you should take Alvarez's class.
Mm-hmm.
And so you have that tension where it's like, okay, is it the letter or is it the spirit, right? Of the
Right.
letter,
Right.
you know?
Yes.
And you can't really like, and you can only make guesses here.
Right. On what
Right.
the author
Yeah.
original intent
Yeah.
was. Yeah.
So yeah, it gets kind of tricky there.
Yeah, I'll give you a perfect example but yes.
So just a quick.
Yeah.
So I think like precaution is pretty applicable here, because ideally, like, the Quran is in itself self-sufficient. It's perfect. So you have something that's perfect, and any derivation, even though small, is going from being to becoming. You get this perfect thing that is the unity of all, and any derivation is essentially, you're starting to delve into flux, something that's not immutable, something that's conditional, something that's can change from 1 week, 1 day, 1 hour to another, or 100 years from now, something that was permissible is no longer permissible.
Mm-hmm.
So it's changeable. Whereas if you just take the literal, if you just follow the perfection that is, is perfect and unconditioned, then ideally you can also live as close to perfection as possible.
Yeah, so the conservative rationalist
Yeah.
and the anti-rationalist said, they coined a maxim that prudence demands precaution, like in those cases. But again, the halal principle is like the liberal sensibilities, and they also had merit. But I wanted to go back to what you were saying, the letter versus the spirit.
Yeah.
I think that's something that Muslims have to deal with when they say Muhammad is our example, but he lived 1,400 years ago. So when he said something, what did he mean by it 1,400 years later? So two examples that I think of is Muhammad says, I eat dates, so you should eat dates, right? Dates meaning, those fruit, like prunes or whatever. And so 1,400 years after him, Muslims eat millions, billions and billions of dates every year, and they think it's part of like Muslim culture to eat it from, far west to east.
Yeah.
But what if in saying eating dates, because he lived 1,400 years ago in that particular place in Arabia, he's not saying I want every Muslim for the next, thousands of years to be eating this product that was specific to Arabia, but he's saying I eat the most agriculturally abundant product and simplest product of my region, and you should do the same. Instead of like eating the most, expensive and difficult to find items, I eat simply. And so for you, if you're living in Asia or whatever, and it's rice, then eat rice. If it's, here it's, so on and so on, So you have to understand these things depending on circumstance and time and place. The other example of this is...
But then it's like, how can you be sure that your understanding of those on the context of those things is an accurate judgment as to what you should do?
But that's the perennial problem that you just asked about your brother leaving a will. After he's died, it's like, do you follow the letter or the spirit? And I would say there's Uncertainty. That's
Yeah.
the problem of being a human that doesn't have perfect knowledge, that there's always uncertainty. And what is our tolerance for uncertainty? Like, if you have a high level of tolerance for uncertainty, then you're willing to speculate more. And there are people who are more liberal, and they're willing to speculate more. They're willing to rely on their own intuition. And for people who have a low tolerance for uncertainty, they feel more comfortable using prudence, using precaution, and staying to the letter of the law. And I think it's like everyone is programmed differently. It really is your own personal. You have to interrogate yourself to figure out what feels right for you, to know which school of thought or which side of the spectrum you lean on.
But the directionality that he's facing tends to, as mathematical master, to be more conservative.
That
Correct.
Sure, they would say prudence
Prudence
requires
if he wants
precaution.
to be normative, he has to burden himself. Even if rationality says, well, it doesn't make sense, but normative commitment to the brother's promise, directionality is towards having painful decisions. And therefore, it's an exercise in meaning-seeking things, knowing rationally that maybe it doesn't make sense. I think that's what happens a lot in terms of how the directionality is being decided through maslaha and through maqasid. And therefore, that's a spiritual dimension comes in that Tabatabai calls knowledge by presence. You smell things, and it's okay, does it make sense? But for the sake of the promise that I made to this, the one who has gone, I'm going to do it this way.
I mean, that's the challenge of the Sabbath, for example,
Sure.
right? If you're saying God does not impose hardship or adversity onto you, or we have not created hardship or adversity for you in religious matters, it comes to a point where some consider the Sabbath to be a hardship, right? And so, but others who did not, they're willing to, against their own sensibilities, say, no, these are the laws of the Sabbath, we have to keep them, and this is a commandment, and so on. And so you have people who say, well, there's the spirit of the law and then the law, the letter of it. And I say, again, this is a perennial problem, or a perennial dimension of being human, if not a problem, because there are those who say, who point to a verse of the Quran that says, where God says, if I had wanted you all, to be one in the same, a nation that is just one with no differences, I could have done that, but I've allowed for these differences, right? And so the
That's
diversity.
Surah 5, right? Surah 5.
I think it's mentioned twice. I don't have the exact verse. And so there are those who take the opinion that diversity is something that is divinely ordained. That God could have divinely ordained singularity and homogeneity, but allowing for this diversity is something that's ordained. And then the verse ends, and we will judge between you all, in the end, basically on the day of judgment, between these differences. So until that time, no one can definitively say they know right from wrong or what is the correct opinion on this. We have 3 more minutes. If there's anyone that hasn't spoken or asked a question and would like to.
I just wanted to know who is the referent object in terms of the making decisions. What is the greater good? It is a democratic process of understanding what is greater good, or it's based on philosopher king or a group of elites or juries. And also, I just wanted to a little bit talk about the white lie or taqiyya in Islamic word actually. This is also a part of maslaha, right? So based on maslaha, you say white lie.
Yeah.
But again, who determine what is actually good for Muslims in general, or is it greater good for them or not? So yeah.
Yeah, that's so in terms of the greater good, I just released a book with my co-author Hassan Ansari entitled Caliphate and Imamate, where we look at different views in Islamic intellectual history on how they legitimized rulers, so medieval Islamic political theories. And one of the takeaways after doing that study for many years is that the majority of Muslims the majority of Muslim jurists, experts of the law, did not respect or believe in democracy and the ability of laypersons to judge or have, you could say, authoritative opinions on the matter, that it's only experts that can interpret these things. So what I've presented to you is a discourse between experts about the rights of experts and how they go about doing this. They would say for laypersons, a layperson is someone who is unable to form an expert opinion on a matter. So it's like you're calling them a layperson by saying they're a non-expert. Anyone who's a non-expert is basically a layperson, and that person is forgiven in terms of their inability to come to an opinion and to know all of the opinions. And they would say an expert is someone who knows all of the opinions and which one is right. You know, like a layperson is someone who's not able to tell you, well, there's opinion A, B, C, or D on a matter. Okay, so what am I getting at? In terms of determining right from wrong, definitely they did not refer to laypersons and their ability to use their discretion on it. They would say that it was the discretion of jurists, experts themselves. So they basically kept they were gatekeepers in terms of their authority and saying that we are the ones that have to judge these things. And when they respected the authority of a ruler, they would also say that rulers had the ability to do this, that military commanders had the ability to do this because they have to use this on the battlefield, and figuring out when to retreat, when to attack. Or rulers had this ability in pronouncing a declaration of war, and jurists themselves had this when they gave their legal opinions. The second question that you asked is the role that the role that jurists believe not only experts but laypersons had in using their discretion in concealing their beliefs, in concealing their views of what is right from wrong. And I would say that it was very commonsensical. They said that to protect your life, you do not have to reveal your opinion on a matter if it's going to get you killed, or you don't have to reveal your practice or some part of your identity if it's going to lead to one's death. And to me that seems commonsensical, but if you have something else in mind, maybe on a state level, you're welcome to share. But yes, that idea for that in early Islamic thought, there was already a view that protecting the life of the human is more important than, let's say, stating the truth on something. I would say, yeah, that idea of the greater good is there because you had basically jurists that said if you have a tyrant who's in power, even if you know the right thing to do is to rebel against that tyrant and to say that they are illegitimate for the greater good, so it doesn't cause to greater bloodshed, individuals do not have an obligation to state that. They can remain quietist in their home and quietly, patiently live through the rule of a tyrant. They're not obliged to fight them or to oppress, to protest them, and so on.
I know we're supposed to go, but I have to ask, because you raised it implicitly what you just said. It is being used a lot against Shia Muslims today, that you cannot make a treaty with Shia Muslims because they use the notion of dissembling. That they can essentially say, I'm going to make peace with you, but I'm really lying to you, and that Islam allows them. You've heard about that?
Yes, anti-Shia sentiment, yes.
Yes, and can you clarify that for us within the context of your lecture?
Okay, I'll take that as one last question. And your last question?
Yeah, I just want to make a comment around the permissibility of states to lie, or the jurists to lie. So, the Platonic notion of you tell people a myth because they're not capable of understanding it, or sacred divine knowledge was relegated to to like mystery cults where you had to be initiated before you're ready to reveal the truth. So is that so would it be permissible for a jurist to sort of make this sort of lie if it's
So
like,
both of those statements are things that I've seen from Muslim philosophers, right, who are part of that Hellenist tradition. They said that many of the symbols and myths related about stories of prophets or so on were used in the Quran or used by the Prophet because individuals didn't have the faculties to understand truth spoken plainly. So you see probably Avicenna and Averroes speaking on that. And the second example that you gave was of
Mystery cults, so.
oh yeah, and then you have occultists who say the same thing. So people who are in the occult sciences would say the same. Who are Gnostics, would say the same thing. In terms of anti-Shi'i sentiment and the belief that it's Shi'is alone who engage in taqiyya, I mean, anti-Shi'i sentiment is based on, perhaps you could say, real grievances and illegitimate or imagined perceived grievances, and I would think that falls in the latter. There are many examples of that, in which, for example, in Iraq, where Sunni Shi'i factionalism erupted with the fall of the dictator Saddam, you had individuals who viewed Shi'is as secret agents of Iran, or in Bahrain the same thing. So Arab Shi'is have had to deal with this, that there's always this suspicion that they are not fully patriotic citizens and that they are secretly supporting the government of Iran, and that sort of anti-Shi'i propaganda and sentiment is something that you see in some of the literature as well. That their legal testimony should be thrown out because of the possibility of engaging in this sort of dissimulation. And I'm not sure what to say beyond the fact that with minority groups, so Jews have had to deal with anti-Jewish conspiracies, from the greater hegemony, and other minority groups deal with that, whether it's in religious matters or in their ethnicity or so on. They have to deal with these stereotypes, and it's unfortunate. But dissimulation is something that both Sunni and Shi'i jurists recognize, and within the case of Shi'ism, it was that because Shi'is would be executed or killed for some of their beliefs, this principle became important, that you had the al-Imam saying you don't have to publicly engage in those practices that will identify you as Shi'i for a larger audience. So like if there's specific rituals or prayers or so on, you can keep that private. You can do that in the privacy of your own homes rather than in the public space where you might be persecuted. And that's taken 1400 years later as a bad thing when it's just using one's discretion and so on. But our time is up. Thank you all.
Thank
for
you.
patiently waiting.